Well, thank you for having me. It's a privilege and an honor to be here. So I'm grateful to have been invited to present to you guys today. I'm going to do a slideshow presentation and then leave time for questions and answers at the end. If you have a question during the presentation, feel free to write it into the chat box so you don't forget, and I'll go through those as well at the end. So I'm going to pull up the screen and I will get started. So a little bit about me. I'm Leslie Sultan. I'm a working mom of 2 kids. I've been practicing law since 2009. I have my own law practice, which I started in 2014. And I have a podcast called The Legacy Purse. So if you're interested in learning more about estate planning, each episode has a different guest that presents on a different topic of estate planning. So one, it would be healthcare directives. One is the history of probate. You know, a lot of people think probate was designed for families to inherit, but it's actually designed for creditors to take their money. So, you know, good stuff out there, Medicaid planning, those kind of things. What's not on my about me is that I am also a cancer survivor. I had thyroid cancer. So I, can share in that space with you guys. All right, so on to estate planning. Did you know 71, according to a recent report, an alarming 71% of Black Americans do not have a will. While the report noted that estate planning for African Americans was up by 12% since 2020, it's still very few that do not have a will or estate plan in place. But hopefully after today's presentation, we'll have several more doing them. So we want to talk about what are some of the reasons why people do not do estate planning. So one of the reasons that I hear a lot is, oh, I don't have enough assets, or I'm not sure how to create one, or they assume that their next of kin will automatically receive everything. They think they're too young, or they just don't want to think about death. For some people, it's kind of superstitious. If I plan, I'm going to die, so I'm not going to plan. So I always like to introduce some of these topics by sharing with stories about celebrities because we can kind of relate to them. So I'm going to go into a few. So the first I'm going to share, as some of you probably already know, the story of Chadwick Boseman from the Black Panther. He died in 2020 at the young age of 43, unfortunately, of colon cancer. At the time that he died, he had a wife. They were only married for 1 year before he passed away. They had no children, and so the other surviving heirs that he had was his parents. So unfortunately, they wound up in probate because he did not do any estate planning. We don't know why. Maybe he assumed that because he was married, his wife would automatically inherit. I unfortunately don't know all the details about the litigation, but luckily it was resolved through a settlement where the wife gets a portion and his parents are getting a portion. Unfortunately, the cost of that litigation was 1/4 of the estate. So he left behind about $4 million, and there's only $1 million or so each going to the surviving heirs because of all the costs that were eaten up through the litigation in probate court. Many of you probably know the story of Aretha Franklin. Her case is still being litigated today. She's known as the Queen of Soul, died at age 76. Her estate is estimated to be worth approximately $80 million. She did not leave behind a valid will, and her estate has been in litigation for years. In fact, in April of 2023, just last month, they submitted voicemails that she had left talking about a will that she was wanting to do and how she wanted certain clauses out of it. So they're trying to use these recordings to prove that she really had intentions of signing a will. Unfortunately, they found several unsigned draft versions over the years of her wills. Some were found like under a couch cushion. So unfortunately, They are not recognizing any of them yet. There's going to be a full trial to determine whether the most recent one can be upheld and then distribute the assets according to that one. But this is a very unfortunate probate matter that, we love these artists, we love these people, and to see their families struggling to enjoy the inheritance is a little disturbing. So what is estate planning? It means having a plan that establishes who will receive your assets and who will carry out your wishes when you become incapacitated or after you die. So it's both to take care of your wishes when you pass away, but also a comprehensive estate plan is going to have advanced directives to take care of you while you're alive, but become incapacitated. So I'll go through some of those documents with you guys. The healthcare directives, and they vary in different states. I know a lot of you are from New York. I'm in New York. I'm also licensed in New Jersey, but every state has some version of these documents. Sometimes they're combined, but I'm going to break them down based on the New York standards. So a living will. This is wishes for your medical treatment, especially if you're in a vegetative state. So if you cannot make this, if you're in a vegetative state, the question is, did you want to remain on artificial nutrition and artificial breathing, or did you want to come off of that and be at rest? So sometimes family members have different opinions about when the plug should be pulled or if the plug should be pulled. The really famous case from back in the days was the Terry Schiavo case. If you remember that, she was very young. She was in her 20s, apparently had an eating disorder and wound up having a cardiac arrest at a very young age. She was married and she had her parents, and she did not do estate planning. So her husband petitioned the court to be a guardian, to be able to make these decisions for her. He was granted guardianship, and when he went to pull the plug, the parents stepped in and stopped it and said no. They were very religious and they were absolutely against that. And they fought with him over this for 8 years. So this woman lived in that state for 8 years with the battle going on. Eventually, after appeal, the husband was granted final decision-making and they were able to pull the plug. And his position was, my wife would not want to live in this state. So that's the living will. The healthcare proxy is where you nominate somebody to make those medical decisions. So if it's your spouse, you would nominate your spouse so that your parents can't come in and do that. Or if you don't really want your spouse to make those decisions, then you can nominate a sibling or a parent. And HIPAA forms, many of you are probably familiar with those, but that releases medical information to your loved ones. So for example, if we're nominating a healthcare proxy and they are not an immediate family member, they will probably not get full access to your medical records to be able to make informed decisions. So signing a HIPAA, giving them that authorization, solves that problem. Last but not least is a power of attorney. This is a very powerful document. This appoints an agent of your choosing to make legal and financial decisions for you. They can sell your house. They can access your bank accounts. So you want to use this document carefully, make sure it doesn't wind up in the wrong hands, but it's very important to have power of attorney in the event of incapacity, because if you're not able to write your own checks or make decisions for capacity issues, and then a guardian has to be appointed for you, and that can be a very expensive, drawn out, lengthy process. Usually these documents, if you did them all with an attorney, it would take less than an hour to sign all of them. And depending on, which state you're in, very reasonably cost. If you do nothing else but just the advanced care directives, you have saved yourself and your family a ton of grief. And it's almost a no-brainer because they're very quick and easy to do. Although I definitely recommend that you do them in your state with a licensed professional. I've seen scenarios where someone in California downloaded a power of attorney that he thought would work in New York. He claims he spoke to an attorney that told him it's the right form. He had his uncle in New York sign it. because his uncle was suffering from dementia and starting to lose capacity. Uncle went into a nursing home and they needed to sell the house to pay for the nursing home. And the title company who approves the sale would not approve the power of attorney. And they were like, this is the wrong form. So he had to hire us to do a full guardianship proceeding, even though they had done, supposedly signed a power of attorney. And a court evaluator was assigned, an attorney was assigned to the guardian. It took several months, and then he was appointed guardian, and then he needed permission from the court to sell the house. And it wound up costing him like close to $10,000. If he had just, done it the first time, it probably would have been a couple hundred. So that's the healthcare documents. I had a whole slide on power of attorney, but we went over that now. So again, it's a legal document that allows you to appoint someone else. They can handle your financial, business, and other legal matters. These can also be updated periodically and changed as needed. So that's a really important tool. If you appoint someone today and, when I was dating my children's father, I appointed him. And then after we broke up, I immediately revoked that and did a new one. So these are, again, easy enough to change, and you should always have them as needed. So it can be used again in the case of incapacity. For example, my mother has dementia. We have to use a power of attorney for her in order to write checks, pay her bills, etc. It can also be used if you're going out of the country or out of state and you need someone to execute on your behalf. So we saw during COVID, for example, people got stuck out of state. They weren't allowed back into the country for some reason. So if they had a power of attorney, that person could go into the bank and do withdrawals or do something on for their benefit. Power of attorney doesn't necessarily have to be mental incapacity. It can also be physical. So if you're in the hospital for an extended period of time, you can give someone the power of attorney and they can use it. And if they're going to the bank or doing something, they can just call you to confirm that you've authorized them to use it. So that's a few different ways for power of attorney. So now I'm going to go into the probate process. We're talking about someone's passed away. Those documents all die with the person that I just spoke about. So power of attorney does not last and go into estate planning. So for that, we're going to talk about the next step. So what is probate? It's a court process required to distribute or take control over someone's assets after they die, with or without a will. If it's with the will, it's called probate in New York. Without a will, it's called administration. So the question really is, how long does the probate process take? For New York, it can take anywhere from a few weeks if the total value of your assets is $50,000 or less, and up to several years if it's more, if it's contested. As I mentioned with Aretha Franklin, it's probably, I don't remember when she died, but it's been years. So obviously, the more conflict involved, the longer this is going to take. And while that's happening, everything's tied up. There's no access to the funds. What is the cost of probate? So generally speaking, when you pass away, your family will be hiring an attorney. Some of you may be dealing with this in your own family where you're going through the probate process for a family member. Most people hire an attorney, although it's not, you can do it on your own. But even as an attorney, I can tell you the forms are very complicated and very technical. I'm constantly getting requests from the clerks to fix something or change something. Each county has different requirements. So it's a little bit overwhelming. Anyways, the cost can easily exceed over $10,000. If there's substantial assets, it could be more. One of the things that we see a lot is because the money is tied up, the banks freeze the accounts once they find out somebody passed away. The family members have no access to the money, which means they don't have the money to pay for an attorney. So in this situation, what do? Some attorneys will take a percentage of the estate. So for example, if you had $1 million estate, a house and a couple bank accounts, and an attorney was going to take 5%, that's $50,000 to that attorney, right? It's a big chunk. That's not what you probably intended for your inheritance to go to an attorney. When there's a risk of recovery, like there might not, there's a contest and where there's a battle and you still can't pay, and there's a risk that there might not be a recovery, some attorneys will take 1/3 of the estate, which is substantial. So it puts the family members in a very dangerous position where they aren't able to pay, or if they do, they have to pay a lot to get proper representation in the courts. So the next question is, if I have a will, can I avoid probate? So the answer is no. A will has to be verified and acknowledged by a judge. What this means is I can't, if I pass away and I leave a will, my family cannot take that will to the bank and say, hey, please give me my money. The bank is gonna say, we have no way of knowing if that person is dead. We have no way of knowing if you just drafted that up in your kitchen, and we are not going to give you the money. So you need to take that to a court, have a judge verify it, have the judge issue you letters, and then bring those letters, usually letters of oh my gosh, the word, I always forget this word. Letters showing that you are the executor of the estate, and then you can get the assets from the bank. So again, no assets can be transferred during this time. If you own a house and you're collecting rent, you technically can't collect any rent. Any funeral bills or mortgage payments you're making for the estate cannot be reimbursed until an executor is appointed. And then even after someone is appointed, the judge might have to approve any transfers or sales. So it can be very burdensome for the family. A lot of our clients are property owners. So, what does that look like? And we kind of touched on this, but the property cannot be sold without court approval. So while you're waiting for the house to go through the probate process, you're paying the mortgage, you're paying the taxes, the value of the asset is decreasing because you're not able to get access and sell it as quickly as you'd like to. Again, family members have no authority to collect rents from tenants unless they're appointed by the court. In some cases, a court will appoint a non-family member as a receiver who would collect the rents and pay the bills and take a fee. More fees go out. And unfortunately, the property cannot be refinanced by the family members, and the loan cannot be modified. So now the family might be struggling to pay their mortgage and now this mortgage so that they don't lose the property. We see a lot of properties go into foreclosure because the family cannot pay it. And the foreclosure default rate, if it was 6%, now used to be probably 3%, now it jumps up to 24%. In interest. So it's very harmful for the value of the assets. So, this can be a big problem for families. And depending on how long it takes, I've got some probate cases in Brooklyn with rental properties. It's been 3 years. We do not have letters. The houses are in foreclosure. The tenants are not paying. The violations are racking up. It's a mess. And it's very unfortunate for the family. All right, so now, of course, the next question is, how can I avoid probate? So the answer to that is a trust. The main one I'm going to talk about today is a revocable living trust. And the way that works is that once you create a trust, the trust then owns the property or the assets. So if you have a house, you would transfer the deed to the trust. You would literally do a new deed, take it out of your name as the grantor, and the buyer is your trust. If you are in a co-op or have shares, stock certificate of a co-op, same thing. As long as the board will approve it, you would transfer that stock certificate, you'd cancel out the first one, and the new one would be issued to your trust. Beauty of a trust is with a revocable living trust, is you control it while you're alive. So you are both the grantor and the trustee. Your control over the assets is then automatically transferred upon your death to the people you named as successor trustees for the benefit of your beneficiaries. The new trustees do not need any legal authority through the courts in order to maintain the trust. They can immediately start collecting rent, paying bills, refinance the house. It's a beautiful tool. The analogy that I like to use as like with my podcast is a purse, the legacy purse. So basically the way it works is you have a purse, you put your wallet in it, you put your deed in it, you put your bank checkbooks in it. You're in control of that purse. If you go to the store, you take your checkbook out, you write your checks, purchase your stuff. If your house is everything is controlled by you and your purse. Once you pass away, the purse just comes off your shoulder and goes to the next person, and now they are in control of your trust. Whatever's in that trust is under the control of the trust. So again, it's a legally binding written agreement between the creator of the trust, the grantor, and the trustee. The trust provides legal protection for all of the assets to ensure they're distributed according to their wishes without any judicial intervention. So another analogy is this red wagon. There's no probate court for the assets that you put into the trust. But if you don't put something into the trust, it will have to go through probate. So the second slide is showing that if something didn't make it into the trust, you didn't put the house in, or you put only the house and then you didn't transfer the bank accounts, then we wind up in probate court. So this is called the funding process. It's really important that once you create a trust, you do the funding process. So if you're working with an attorney, you want to see, make sure they get involved at some level with the funding process. All right, so I'm not sure if any of you have minor children, but estate planning is really important, especially for parents of minor children. We are the very vulnerable, and so are our children when it comes to estate planning, because minors cannot inherit. So what does that mean? If we don't do estate planning and I pass away, somebody has to be appointed to manage the money for my children. And so if I haven't appointed somebody, guess who's going to do it? The courts. So the best thing to do, obviously, with estate planning is you nominate a guardian and a trustee. The trustee would be in charge of the money, and you can specify when the assets go out. So for example, most people don't like the idea of minors inheriting money and receiving everything at 18, right? Like, do I want my 18-year-old to potentially have hundreds of thousands of dollars in their bank account? Maybe not. So with the trust, you can create it so that a little bit goes out at 18, or you could even wait till 21 or 25, or when they graduate college. Hold the rest until another stage or age, like 30, or when they have a family, and then they get a little bit more, and then another portion once they're 35. This allows them to, practice managing their own money and learning how to spend and save, and really, manage their inheritance well. So obviously, estate planning is about nominating guardians for minor children in the event that one or both parents cannot raise the children. So, something to think about: if you have minor children, who would raise your kids? If you haven't appointed a guardian, anybody can petition the court to be a guardian. Would you have conflicting in-laws, grandparents fighting, or conflicting aunts and uncles fighting for that guardianship? So although we can't officially appoint someone, we do nominate someone as a guardian, and the court will take that into account in the guardianship proceeding. We also recommend doing both temporary and long-term guardians. So what's the difference? Long-term guardian is going to be that legal guardian making all the legal decisions. But for example, the first person I would want to be a legal guardian for my parents and my children lives in Canada. So if something were to happen to me and my kids need to be picked up from school, there's no way she's going to make it down from Canada in time to get them. So I can nominate temporary people that will have legal authority to pick them up and hold on to them until she can come in from Canada. If we don't have that, it's very likely that the school is going to call Child Protective Services and have them hold the children. And that is definitely not what I want. So that's why I would do the temporary also. All right, so let's assume we have a plan. We also want to talk about revisiting your plan. So if you've already done estate planning, congratulations and great job. But we do want to think about when to revisit that plan. So obviously, if there's a new family member, a new child, marriage, or divorce, if you're buying a new home, if your beneficiaries are changing, so you want to change somebody, you don't want them to inherit anymore, or somebody passes away, They really, you have to update your beneficiaries. You might want to check to make sure everything's changed. And also if you're moving to another state, because different states have different rules. I gave you the scenario for New York, which is a very difficult probate state. There's other states like Jersey is what we call probate friendly. All of those scenarios, the long delayed time, don't generally happen in a probate friendly state. It's much easier. So you want to check and find out what your state is like. How easy, how complicated would it be if you did nothing, and go from there. So I don't want to talk only about the bad stuff. I also want to talk about the good stuff. So some examples of celebrities who did do estate planning. Kobe Bryant of the Lakers. I'm from LA. Hey. So Kobe Bryant unfortunately died in 2020. He was a famous basketball player, also a savvy businessman, brand builder, and investor. He had a very well done trust in place. Unfortunately, he died at 41, but he had taken care of and moved all of his assets into a trust. And so his family was very well taken care of. There was a minor detail that had to be resolved in court because he had another child after he had done his estate planning, and apparently the language did not clearly specify all my children. It had listed out his specific children. So there was some court involved in that, but generally speaking, the daughter was added and everything was moved along through the trust. Who's behind the last curtain? Okay, Whitney Houston. Oh, this is a very heartbreaking story. So Whitney Houston died in 2012. She did do estate planning. However, she did a will. As you know, she was married to Bobby Brown. They were divorced and they had a child, Bobby Christina. So when Whitney Houston died, her will was probated. And in her will, she specified that money would be set up into a trust. We call this a testamentary trust. So the will puts the money into a trust for the benefit of the child. So if there's no way for you to do a trust, the very least you want to do is a will with a testamentary trust, as opposed to the revocable trust that I mentioned earlier that's outside. It's not my favorite way because if I have to go to court and pay, why would I do that if I could set up a trust outside? So we don't know why she did it that way. But in her will and her testamentary trust, she specified that everything would go to her daughter. A portion of it would go at 18, another portion at 25, and another portion at 30. So Bobby Christina inherited a substantial amount of assets at age 18. Unfortunately, Bobby Christina died the same fate as her mother at age 22. And Bobby Christina did not do estate planning. So who do you think inherited all that first chunk of money? Bobby Brown, Whitney Houston's ex-husband, which I'm sure is not what Whitney Houston wanted. Luckily, she did have those other distributions sections. So the other portions that did not go to Bobby Brown went to Whitney's sisters, which is how she had specified in her will. If my daughter has predeceased me or dies, then that share goes to my sisters. So at least they were able to save some portion of her estate, and Bobby Brown did not inherit all of it. Rosa Parks, the mother of the freedom movement, had a very modest estate valued at a reported $372,000. But at the time she wrote her will in the mid-'80s, she created a nonprofit organization called the Rosa and Raymond Parks Institute for Self-Development. And she donated through her estate plan important and valuable civil rights documents and artifacts. So we don't know exactly how much those are valued, but they believe it's well into the millions. So she took the time to make sure that those documents went exactly where she wanted them. And so her legacy is able to be protected and remains through that process. The last story I like to share is from Myleik Teal, the founder and CEO of Curlbox. She is a mother of two and the founder of Curlbox. She was actually able to use an inheritance that was left to her by her godparents to fund this business. So it's just one example of how people can benefit from estate planning. So I like to leave that at the end. because it's a really beautiful the way she shares her story. Like she just needed a little bit and she inherited it and boom. So it's a nice story to tell. So key takeaways, doesn't matter how old you are. It doesn't matter how much assets you have. The superstition shouldn't matter. You definitely want to at least consult with an estate planning attorney in your state. Do at least the healthcare documents, make sure those are in place. And if you have minor children, you definitely want to do guardian nominations and look into your options for what would happen in your state if you passed away and did nothing. And if you like that plan, cool. If you don't, then you have to put something in writing to document it. So I will go over to the chat box and see what questions popped up.
No, thank you so much, Leslie. That's a lot. So we all need to breathe. Like, whew, yeah. It was a lot of just great information. So we're going to definitely take some questions. I know Michelle had her hand raised. And I knew someone else. So if you guys want to unmute, it's starting with Michelle and just ask your question. Thank you. Thank you, Leslie.
You're welcome.